And now moving on to our presentation, please join me in welcoming our presenter, Aren Ash, staff attorney from Housing and Economic Rights Advocates. Aren.
Good morning, everyone, and thank you, Catherine and Leah. My name is Aren Ash. I'm a staff attorney with Housing and Economic Rights Advocates, or HERA. HERA, we're a statewide nonprofit, and we focus really on California's most marginalized communities, and we provide free legal services to low and moderate income people across the state. And I focus on mostly landlord-tenant issues and some debt issues, but we cover a wide range of issues, which I'll go over at the end of this presentation. So we really encourage anyone to reach out to us because, like I said, our services are free to low and moderate income people in California. And a little bit of background about myself. I've been with HERA for about 2 years. Before that, I was in private practice, and before going to law school, actually, I was a chef in San Francisco. So now I'll get started with just a quick kind of rundown of our agenda. So first, I'll kind of go over an overview of the COVID eviction moratoriums, what that meant. Although most of them have expired, I'll go over some of the moratoria that are still in effect right now. And then, more importantly, really, I'm going to go over what the state of eviction protections and rent control and landlord-tenant law is now coming out of COVID and post the moratoria. So I'll cover things like tenants' right to privacy, laws around security deposits. I'll briefly go over habitability, but I believe there'll be a link to, under this video to one of my previous presentations that really went into depth about habitability. And then I'll also cover some basic kind of tenant relationships that we see issues with a lot, and then fair housing laws. And then, like I said, at the end, I'll provide some additional resources, go over what else we do at HERA, and then I'll leave plenty of time for questions. So if you want to put your questions in the chat, I can go in there and answer those at the end. Or if you want to save the question and just ask me directly over Zoom, that's fine. So a moratoria is really a temporary ban of certain activities. And as most of you probably know, from March 2020, the beginning of the pandemic, through September of 2021, there are a lot of eviction moratoriums at the federal, state, and local level really passed in order to prevent the transmission of COVID-19. As I mentioned, unfortunately, most of those protections have expired, including Alameda County's eviction moratorium, which was in effect until the end of April of this year. Same thing with the city of Richmond, and then more recently, the city of Oakland's moratorium did expire. There are a couple localities here in the Bay Area that still have moratoria in effect. The city of Berkeley and the city of San Leandro, which I'll go over what those cover, but those are both ending pretty soon as well. So the city of Oakland's eviction moratorium, that expired on July 15th of this month. So that's ended. That means that evictions for non-payment of rent, material lease violations, and all of other types of evictions are not exempt they're not exempted anymore. And basically tenants can be evicted for non-payment of rent. It's really important to note that tenants in Oakland can't be evicted for non-payment of rent that came due during the moratorium. They can only be evicted for non-payment of rent after the moratorium. So if you didn't pay your rent during the moratorium, I'll cover it a little bit. You still can get sued on it, and technically you are still liable for it, but you can't be evicted for that rent. And then there still is a rent increase moratorium that the rent increases are capped at 3%, and then there's some other caps as far as pass-throughs and what's called banking of rent increases, that those will continue until next year in July. So the city of Berkeley's eviction moratorium will expire in 2 phases. So the first phase has already ended. that was basically the covered period. And during that period, only evictions necessary to ensure the health and safety of other residents were allowed. And then so phase two, which we're in right now, this is the transition period. So during this period, evictions are allowed really for only a few reasons: to ensure the health and safety of residents, for owner move-ins, and then for non-payment of rent that came due during this period of phase two. And again, tenants can't be evicted under this moratorium for rent that came due during the moratorium. It has to be after. And then the city of San Leandro also has an eviction moratorium. It's a little more limited, but that is in effect until the end of this month. And then really it's limited for evictions for non-payment of rent, where the inability to pay rent is really due to decrease in household income or an increase in medical expenses caused by the pandemic. So it really only applies to tenants who have submitted written notification to their landlord that they can't pay rent due to COVID-19 reasons. And in San Leandro, they actually have to submit that documentation every month. But like I said, that is expiring on July 31st. There is going to be a 6-month grace period after that, where tenants can pay back past due rent, but the eviction moratorium does end on July 31st. So even if you live in a city where there's still an eviction moratorium in place, like I said, you can't get evicted for not paying rent during the moratorium, but you're still technically legally obligated to pay the rent. And what that means is, while they can't evict you, they can technically sue you in small claims court or in civil court if it's beyond $10,000, which is the limit for small claims court, for back rent, even if it was during the period of the moratorium. However, there are limits of what they can report for tenant screening and for credit reports and stuff like that. So from March 2020 to September 2021, they can't use that as a negative factor in tenant screening. So at least you're protected from that. But otherwise, the landlord still can come after you in small claims court or in civil court, like I said, to get that back rent, even though you couldn't be evicted for not paying. So now that most of the moratoriums are over, it kind of reverts back to the general landlord tenant law in California, which is kind of a patchwork because we have state law, and then there's also local protections that kind of go beyond the state law, which I'll now cover. So really, landlords have to provide tenants with prior written notice in order to evict them for any reason. A landlord can't just tell you verbally to get out. It has to be written. And what written means isn't text, isn't email. Really, they have to give you a letter, a physical letter, either by personal delivery, which means handing it directly to you, or by like posting it and mailing it to you through the mail. So that's really important that, landlords can't just tell you, oh, you need to be out on this day. Getting that written notice is really important. And, we suggest definitely, if you receive any kind of notice that you're being evicted, or a 3-day notice or something like that I'm going to cover right now, definitely reach out to us or one of the other tenant nonprofits that I'm going to list at the end of this, because usually there's timelines, and a lot of times, like I said, maybe it isn't in writing, or maybe there's some issue with it. So you can usually either get it invalidated and get them to withdraw it, or get an extension of time. Or if it is valid, you do have to respond within a certain amount of time, or you could actually face eviction. So they have to provide written notice for any reason. And, the notice period really varies depending on why they're evicting you. In most cases, tenants do have a cure period, and usually that's for non-payment of rent or a lease violation. And that's when you've probably heard of people getting a 3-day pay or quit notice or a 3-day comply notice. And that's usually what that is for these curable lease violations or non-payment. And the landlords are required to provide that, and they have to, again, give that in written notice to the tenant before they file an eviction lawsuit. However, sometimes if the violation is really bad, like substantial damage to the property or some severe criminal activity, a cure period may not be required, and you may be required to vacate in a certain time frame. But usually that's very specific circumstances. So then, so for notice of termination, if a landlord just wants to terminate a lease, if a lease is month to month, and a tenant's been living there for at least 30 days, the landlord has to provide the tenants with 30 days written notice. If they've been living there for more than a year, then the landlord has to give 60 days written notice. Now, if it's a fixed term lease, for example, if you have a 1-year lease, in most cases, the landlord can't terminate that without cause before the end of the term. So without you violating the lease or not paying rent or something like that. And usually the lease changes to month at the end of the lease term, unless you agree to something else or you renew it or there's something else in the lease. But usually the end of the lease doesn't constitute just cause to evict a tenant, but a tenant does potentially risk eviction for refusing to sign a new lease. So I'll go over now, kind of what just cause is, because, before 2020, when the Tenant Protection Act was passed in California, landlords generally could, just decide to terminate a tenancy, giving proper notice once that initial lease period expired. But luckily in 2020, the Tenant Protection Act was passed, and that gave certain tenants rights in certain units to not be evicted unless the landlord has just cause or good cause to evict them. And there's 2 different types of just cause or good cause, or basically reasons why a landlord can evict a tenant who is in a covered property under the Tenant Protection Act. So the first type of just cause or good cause is called no fault just cause. And that is the circumstance where the tenant hasn't violated any lease terms. And usually that's when an owner wants to move in or an owner's family member wants to move in, or if the owner intends to demolish or substantially remodel the property. Also, if the landlord is just completely withdrawing the unit from the rental market, and that's called an Ellis Act eviction, which you may have heard of. Also, in order to comply with a court order, or in order to vacate something related to habitability. For those no fault just cause reasons, when the tenant isn't at fault, when the landlord is taking one of these other avenues, such as Ellis Act, the landlord may be required to pay for relocation assistance to the tenant under the statewide, this Tenant Protection Act. But then also, as I'll go over later in this presentation, there's some stronger and more robust relocation assistance laws on the local level, especially here in the Bay Area. So then the other kind of good cause and reason why a landlord can evict a tenant in one of these covered properties is at fault just cause. And now that's when a tenant has actually violated a material term of the lease, such as, damaging property or something like that, or engaged in other actions that are in violation of the lease, non-payment of rent, refusal to allow the landlord to enter when they have a good reason to enter and they've given you proper notice. A landlord still can technically evict a tenant, for those reasons. But really, those are the only reasons why that a landlord can evict a tenant if they're covered by the Tenant Protection Act. And, that's very important to know if they're covered, because these just cause protections that I just went over don't apply to all tenants. They apply to many properties, and most of the time, if you're in like an apartment building or a building where there's more than a few units, you will be covered. But there are various exemptions to this, and some of them are listed here, but this is not an exhaustive list. So definitely, if you're wondering if you're covered by these just cause protections, you want to reach out to us or another organization to really look at your property to see if this law applies to you, because hotels, nonprofit hospitals, student dorms aren't covered. duplexes where the landlord lives on the property, units built within the last 15 years or that have received their certificate of occupancy within the last 15 years. Those aren't covered. And another one of the bigger exceptions to this law and to the just cause protections is a single family home that's not owned by a corporation or an LLC or something like that, that's basically owned by an individual person. Those are actually exempt, but there are, disclosure requirements and very specifics for each one of these exemptions. So like I said, if you're wondering whether you're covered, definitely reach out to us and we can look at your situation and determine whether you are covered by the Tenant Protection Act. So notices under the Ellis Act, which I mentioned, which is a type of no fault eviction that landlords can implement to take the property off of the rental market. And that's a pretty common loophole basically, or exception that was carved out that landlords use to basically get back their property or to evict a tenant. And at minimum, a landlord has to give 60 days notice to vacate if it's going to be this type of Ellis Act eviction. But like I mentioned, cities have their own rent control laws that can impose longer notice periods and additional requirements on landlords. And especially if you're disabled or elderly, there are even more protections for you or extensions on that period at least. For example, some cities impose like a 120-day notice period for Ellis Act evictions and 1-year notice period for tenants who are disabled or seniors. So definitely be sure with this, as with anything else, because these laws are pretty complex. And like I mentioned, it's kind of a patchwork on the state level and the local level. So definitely check your local laws and speak with an attorney if you're served with any kind of notice, even if it's just a 3-day pay or quit notice or cure notice or a notice to vacate, because a lot of times landlords make mistakes with the content of the notice because there's very specific language that they have to put in there. And if it's not compliant with that, then you may have a right to more time in your unit. So the Tenant Protection Act it also implemented statewide rent control. And again, this only applies to certain units, and it's similar exceptions as are listed here. So single family homes, buildings that have received their certificate of occupancy that's less than 15 years old, and other exceptions. This also isn't an exhaustive list of those exceptions, but for properties that are covered, rent can't be raised by more than 5% plus the local consumer price index, or 10%, whichever is lower. And for most of the state right now, because of inflation and stuff, that is 10%, the 5% plus local CPI. It's more than 10% in some places, so it kind of defers back to the 10% that's lower. You can look up your local CPI on housing authority websites or the US Bureau of Labor and Statistics, which I've included here. But basically what rent control is rent can only be increased twice in any 12-month period, and combined, if they're doing it twice or just once, it can't be more than that 10% or that 5% plus local CPI. And landlords have to provide proper rent increase notices to tenants. And what that is it's written notice. It's within a certain amount of days. If it's below 10%, it has to be 30 days. If it's mailed, you actually get an extra 5 days. And if it's above 10%, so say you're not in one of these covered properties, then it actually has to be 90 days if it's above 10%. So that's something to keep note of, and definitely, it has to be in writing, like with the other notices. So cities also can enact ordinances to protect tenants from displacement. And luckily here in the Bay Area and in Alameda County, especially, cities have done that at different levels. So Berkeley, Emeryville, Hayward, Oakland, Alameda, Union City, and Fremont have all implemented different types of these rent controls or just cause kind of buffers to strengthen their laws on top of what the state already has. So in Berkeley, Oakland, Alameda, Hayward, and Fremont, they each have some form of rent review or mediation or rent stabilization. And that's really a way for the local government to regulate the cost of rent in certain circumstances and beyond, the state's rent control. But again, on the local level, not all units are eligible. So it's really important to look at your local laws or contact an organization like us to find out, if your unit's covered by those laws. And then Union City also has rent review and mediation. And that really is a process for a local municipality to kind of streamline and have their own system for determining whether rent increases are legal. And it's really a different process depending on what city it is. But like Oakland, for instance, it's the RAP, the Rent Adjustment Program. And it really just creates this system where tenants can go and file a petition if they think the rent increase is unjust, and they don't have to kind of go through and file a lawsuit in court or something like that. So those are really helpful. And then in other cities, such as Oakland and Berkeley and even Hayward, they have special relocation payments in certain circumstances where the landlord may be required to pay relocation expenses beyond what the state requires, because the state really, for those Ellis Act relocations and other types of no fault just cause evictions, really the relocation payment is either 1 month's rent that you receive, or they just waive the last month's rent, where in places like Oakland and Berkeley, it's a good amount higher, and they kind of base it on what how many bedrooms you have and really what the cost is to move and find a new place. Because in most circumstances, that even though it's good to get 1 month's rent back or waive 1 month, that really, especially in the Bay Area and in most of California, that really isn't enough. So it's good to have those expanded relocation payments in places like Oakland and Berkeley. And even in Oakland, if a landlord, say, wants to start negotiating with a tenant to move out, which is very common because Oakland has such strong tenant protections, there's very strict requirements that landlords have to follow to even initiate those move out negotiations, such as providing them with disclosures about the law and all of that. So it's it's really important to look at your local laws and talk to someone like us, even if your landlord is starting to talk to you about, like, hey, do you want to move out? What if I pay you to move out? Because they could be breaking laws just by initiating those conversations without providing you with specific documentation. So now I'm going to go over some basic tenants' rights issues that we really face a lot on a day-to-day basis. So the first is limits on landlord entry, and really this is based on a tenant's right to privacy. So in general, a landlord has to give reasonable, which is, it's not in the law, it doesn't say 24 hours, but that's kind of the general understanding, and it really depends on what the issue is, but they have to give reasonable written notice. Again, it has to be written to the tenant in order to enter the unit. And typically this is to make agreed upon repairs that are necessary, or just agreed upon to show the unit to a prospective renter, or to do a pre-move out walkthrough that, say, the tenant requests so they can maximize their security deposit return. Now, in limited circumstances, the landlord can enter without prior notice, such as like an emergency, if there's a flood or a fire, if the landlord obtains a court order permitting entry, if the tenant has abandoned the unit, or if the tenant consents to entry. But the landlord can't just, go in there for random inspections. They really have to have a good reason, such as making agreed upon repairs, showing the unit, or doing a walkthrough or something like that. And really, excessive attempts by a landlord to enter the unit to just inspect or just take a look around or something like that could indicate something else, like harassment, retaliation, or discrimination. So that's definitely something to keep in mind. And really, if your landlord is excessively attempting to enter your place, or they're not giving you written notice, it's really important to keep documentation of any of those issues. So definitely write down dates and times, keep notes if there's any witnesses, especially if there's no documentation of your landlord requesting to enter. So the next issue I'll cover is security deposits. This is one of the most common issues. So there are limits on how much a landlord can actually charge for a security deposit when you move in. For an unfurnished unit, it's 2 times the rent. And for a furnished unit, it's 3 times the rent. Sorry about that. So they can only charge that much. And then when you move out of your unit, they can only make certain deductions from your security deposit when you move out. And those allowable deductions really are just to cover damages beyond normal wear and tear. And that's, how normal wear and tear is determined is really based on how long you've lived there, so the wear and tear on a carpet, for instance, will be much different for someone who's lived there for 1 year versus 10 years. So that kind of determines, what the landlord is allowed to deduct and to charge you based on, the wear and tear that happens. So they can also charge basically to clean the unit, to make it as clean as it was when you moved in, and then also to cover unpaid rent. Now, the landlord has to return the full security deposit or a portion of it minus those deductions I just mentioned within 21 days after the tenant moves out. And if they don't, it can be considered a bad faith retention or an unlawful retention of the security deposit, and could potentially make them liable for double damages for that unlawful retention. Now, if they do make a deduction and they're sending you back only a portion of that security deposit, they are required to put in writing any remaining they're required to give you any remaining refund, put in writing a letter explaining those deductions, give an itemized list of the deductions, and if it's over $126, the landlord has to provide receipts for those deductions. Now, if you're planning on moving out of your place, you do have a right to request a pre-move out inspection from your landlord. So basically they can come and walk through, and that's usually done with, within 2 weeks of you moving out, and they are required to do it if you request it. And basically they'll come in and walk through and let you know what they anticipate the deductions will be. So that gives you an opportunity now to go and fix those issues so you can maximize the return of your security deposit. And if they don't return your security deposit, or if you want to challenge the deductions, small claims court is actually a really good route for that. And we can help you kind of, although you're not allowed to have an attorney in small claims court, we can definitely give you some guidance and in that process. So I'll quickly go over some basic tenants' rights related to habitability. Like I mentioned, I previously did a presentation that went into depth about this. So definitely I would refer to that if you want to get a deeper knowledge of it. But in general, tenants have the right to live in a habitable residence, which really means it's healthy, safe, fit for human occupation, and the landlords are required to provide that. So that can be anything from obviously mold, asbestos, lead, structural elements being intact, so there can't be faulty stairs or walls. Landlords do have to provide hot and cold water, working plumbing, electrical, and really take reasonable measures to prevent break-ins, criminal activity on property, especially if it's foreseeable and things have happened before. That's not an exclusive list of things that fall under habitability. Usually, like I said, it's things that affect health and safety. And there is a list in the civil code that lists a lot of the things, but also local health and safety codes cover this. So there's, it's really healthy and safe conditions. It's not necessarily aesthetically pleasing conditions or everything being perfect. It's really things that affect health and safety. So ideally, landlords would keep up on these issues, make repairs, but landlords don't do that all the time. A lot of landlords, are in business, so they might not necessarily be the fastest to repair things because they're watching their dollars, but that's no excuse, and they are required to repair these habitability issues. So the first thing to do is really document everything, and that's really with anything with landlord tenant issues and anything with your relationship with your landlord. It's really important to document everything with dates, timestamps. If there's witnesses, taking down their information, taking pictures if you can see these issues, and then requesting the repairs in writing from your landlord. So that's really the first step, is to request those repairs in writing. Now, it's not required under the law to request repairs in writing. Technically, you can request them orally or by text or email. But, if the landlord ignores you, or if eventually you have to take one of these routes that I am going to go over in a minute to force your landlord to make the repairs, you want to be able to show that your landlord actually had noticed that this issue existed. And if you text them or email them or just call them or say it in person, if they deny that ever happened, it's a lot harder to prove that they actually received that notice, because they could say an email went to spam, or if they aren't responding directly to text messages or emails, there is potential, that they could just deny it. So what writing means is, writing a repair request letter, basically saying there's these issues, I'm requesting you to fix it, and sending it via certified mail, so through the post office. And what we recommend is having tracking on that, and so you can actually confirm that the letter was delivered by using the tracking number, but no signature required, because if you require signature, then it might not get delivered if no one's there. So really just doing certified mail with tracking, but no signature required. And you can also do it verbally or by email or text, but I think always following it up with that repair request letter in writing in the mail is really important, because like I said, if you have to go and sue them to try to get them to make these repairs, then it's really important, that you can show the landlord actually had noticed that the issues existed. So now what happens if the landlord doesn't fix the issues? You've written this repair request letter, you've asked them to fix it, and they're just maybe denying that the issue exists, or they're just delaying, or just straight up telling you no, that they won't fix it. So the first thing to do, and usually we'll include this in a repair request letter, is letting the landlord know that, hey, if you don't fix this issue, we're going to call code enforcement to come out and take a look at it. And now in different places, it might be code enforcement, it might be the health department or something like that. But what happens when you call code enforcement is you let them know that there's this issue in your home that you feel like is a health and safety issue, and they'll send an inspector out to come and take a look at the issue. And when the inspector comes out, if they find that this issue actually exists, they will they'll fill out a report and basically give a citation or a violation. It depends on the locality what it's called, but basically it's an official notice telling the landlord that they have to fix this issue or they'll get fined. And they usually give them a certain number of days. So that's usually a really good tool to get the landlord to fix it, because now they're potentially facing consequences from a government authority regarding it. And also if the landlord still doesn't fix it, it creates that record, that official record for you, and really good evidence for you to take if you do end up having to, sue the landlord or force them to fix it. Having that documentation from the code enforcement, from an official inspector saying that they came out and this issue exists, in addition to all your documentation, can be really, really helpful. Now, if say code enforcement comes out and the landlord still isn't fixing things, there are other remedies that you can take, but those remedies are a little more risky, and I'll just touch on those quickly. There's the repair and deduct remedy, and that's basically when a tenant notifies a landlord that they're going to do the repairs themselves, and they're going to deduct it from the rent that they're going to pay. Now, the risk of this is that your landlord can, if you say you fix something and it costs $100, and now you've paid $100 less than what your rent is supposed to be. If your landlord disagrees with the repairs, or if they think that there isn't an issue, they could potentially try to evict you. And then it really comes down to the facts. Did the landlord have notice? Did this issue exist? And did they get a reasonable time to fix it? And for that method, and for any of these methods, really, we definitely suggest reaching out to us or another attorney to talk about it, because of that risk of eviction. And with the repair and deduct method, you do have to give the landlord written notice that you're planning to do it. You have to give them reasonable amount of time to fix it, which is usually 30 days, but it's really dependent on what the issue is, obviously. And then if you do, you have to provide them with receipts for the repairs that you did yourself or had someone come do. And it's usually an idea to have a third party or a professional come and do it, because it's a lot easier for a landlord to contest a dollar amount if it was just you doing the repairs versus a professional and you receiving the receipts. Withholding rent is another, similar to repair and deduct, but that's when a tenant just withholds a portion of the rent, and usually that's a percentage based on the lack of housing services or the limited use of the unit. And again, that's another very, very risky route, because again, the landlord could contest it, that the issues ever existed, and could then try to evict you for non-payment of rent. And then another, route is small claims court, and you could take a landlord to small claims court for a repair order or for damages related to whatever the habitability issues are. And in small claims court, the limit is $10,000. And you're not allowed to have an attorney. The landlord's not allowed to have an attorney. And it's kind of a less formal venue than civil court, which is above $10,000. So it's usually, you're just in front of a judge and it's getting down to the facts. And that's when these having these request letters in writing, having all the documentation is really important to show that you gave the landlord notice that the problem existed, that the problem actually existed, and then that they failed to fix it within a reasonable amount of time. And depending on the extent of the habitability issues, such as like floods or fire, something that's really extreme or really bad mold, a landlord may actually be required to temporarily relocate a tenant and like into another similar unit maybe, or pay for hotel costs while the unit's being repaired. So now I'm going to quickly go over some one of the most common kind of tenancy relationships that we see issues arise with, and that's subtenancies or subleasing. So in a normal tenant-landlord relationship, there's a tenant or there's co-tenants, and those co-tenants or the one main tenant have a lease directly with the landlord. And if there's multiple people on that same lease directly with the landlord, they're actually what's called joint and severally liable to the landlord. And what that means is if rent isn't paid, or if there's some lease violation and there's damages, the landlord can actually sue any of the tenants for the full amount. So they're jointly liable for the whole amount. So now the other kind of tenancy relationship is a subtenancy, and that's usually so there's the master tenant who has the original lease with the landlord. When they either want to, they're still under their original lease, but they want to maybe rent out or sublet their entire unit to someone else, or what we see a lot, especially in the Bay Area, is if it's a roommate situation. If there's a master tenant, they have the original lease, maybe one of the original co-tenants moved out, and now the master tenant wants to bring in another roommate. If that new roommate isn't added to the original lease, or if they don't have a direct lease with the landlord, then they would be considered a subtenant, and there's really special responsibilities and rights that go along with that relationship that are different from the normal landlord-tenant relationship. So in California, a landlord may actually be able to refuse to allow a tenant to sublet, but that's only if the lease clearly and explicitly says that you cannot sublease. Whereas if the lease requires a landlord's permission, which is more common clause in a lease, the landlord can't unreasonably withhold consent from the tenant. And under, if you are subletting, that original tenant, the master tenant, remains responsible for the terms of that original lease. So just because you're subletting and you're moving out, maybe even, and subletting the whole place, it doesn't relieve you from that responsibility and liability to the landlord who you have that contract with. And to that point, the master tenant is responsible for paying rent to the landlord for all the tenants, which means they have to collect rent from the subtenants. And the subtenants, don't pay the landlord directly. If they did, that could establish an actual direct tenancy relationship. And if the landlord's accepting rent directly from the subtenant, the master tenant should ensure that subtenants follow all the lease terms, because you could face liability, like I said, for violations of subtenants, because really the landlord doesn't have a direct contract with that subtenant, so they don't have the legal right to go after them for violations of the lease, because there is no lease, there is no agreement with them. So if that subtenant violates the lease, then the landlord is most likely going to come after you for whatever the issue was. So that's why it's a really good idea, if you are a master tenant and you're bringing in roommates or you're subletting your whole place, to enter into a separate agreement or sublease with that subtenant, and make sure that that agreement is, enforcing all of the same clauses and agreements that are in that original lease with the master tenant, just so you're covering yourself if the subtenant violates any of those lease terms. Now, the master tenant does have the authority to evict subtenants, but has to follow all the same local, state, and federal laws that a landlord has to follow. And they can't retaliate against a subtenant for standing up for their rights. So a lot of the notice, the just cause, all of those issues that I went over earlier in this presentation, those apply to a master tenant and subtenant relationship as well. So really what that means is, if you're a master tenant, you're effectively stepping into the shoes of a landlord, and you are becoming a landlord to the subtenant. So that's why it's really important to consider that responsibility and do your due diligence on whoever you're subletting to, just to make sure that they're going to be a good tenant, because or a good roommate, because otherwise you could end up liable. And now subtenants should really read the master lease before signing a sublease. So if you're going to sublet for someone and they're not the actual landlord, or if you're moving into a place and there's roommates, it's really important to read that master lease before signing the sublease, to make sure that that master tenant even has the right to sublet it in the first place. Because like I said, if the lease clearly prohibits and explicitly prohibits subletting, then you all could potentially get evicted for an unlawful sublet in violation of the lease. So that's why it's really important to read that lease, to make sure that subletting is even allowed, and also to make sure that you're paying your fair share in rent, so you can see what that amount is, and to kind of make sure that that master tenant isn't profiting off of you. And some localities like Oakland have even stronger protections, where it's actually in the law that a roommate or a master tenant cannot charge a subtenant more than their portion of the rent. And you can go through the rent adjustment program to remedy that issue, just like you can for an illegal rent increase or something like that. And that's something we've dealt with before, and we help tenants with all the time, kind of going through that petition process with the different localities and rent boards to contest an unlawful rent increase or unlawful eviction or other tenant issues. And in most cases, as I mentioned, if those just cause protections apply to the property, then they also apply to the subtenants. So really, the master tenant has to follow all the same laws as the landlord, as far as evicting, noticing requirements, just cause, all of that. The master tenant really is kind of becoming a landlord when they're subletting. So applying for housing, it's really important to inspect a unit before you rent it, to meet whoever the owner is or the property manager is who's renting it out to you, because there are a lot of scams out there right now, especially since COVID. I just had a friend actually yesterday who was looking at a place in Berkeley, and the landlord said they were out of state and they were asking them for all this personal information, and it definitely seemed like a scam, because they basically wouldn't let them actually go see the place. They were just sending them pictures, but yet they still wanted them to sign a lease and give them a security deposit. And we see all sorts of these types of scams all over the place. So that's why it's really important to go and physically inspect the rental unit before you go, to make sure that it actually exists, but also to make sure that the conditions are good, that it's habitable. If you are deciding to rent it, to go and take pictures, make sure to note any issues. So then, when you move out eventually, you can show that that these issues existed already, and the landlord doesn't try to charge you or deduct from your security deposit. Now, landlords can't charge more than the price set under California law for an application screening fee. And sometimes we see landlords try to get away with charging more. It's dependent on the CPI, and it's constantly changing. But right now, I checked a couple days ago, and it's around $59, the maximum amount that they can charge for an application fee. And importantly, applicants have a right to copies of all reports a landlord uses to determine whether or not to accept them as a tenant. So if a landlord denies your application based on your credit score, or some tenant screening reports, there's a lot of these tenant screening reports that create like a tenant score, the landlord has to provide you with copies of those reports if you request it, and they have to provide you with a letter stating that you have that right, that the denial was based wholly or partly on that report or credit report or screening report. And they do have to provide you with, the name, address, and phone number of the reporting agency. So now you can go and look at this report, make sure everything's accurate, and if necessary, try to fix those inaccuracies. So now I'll go over some just basic fair housing laws. So both on the federal level and the state level, there's fair housing laws that protect tenants from discrimination in the rental process and in purchasing homes. It's unlawful for a landlord, agent, broker, really anyone that's providing housing to discriminate against a person because of race, color, religion, sex, military service, source of income, disability, age, medical condition. And that can come in a lot of different forms. So it's really important, like I said, to document things. If you think something's off, if you think someone is discriminating against you, to note that. Some common violations of these fair housing laws are, for instance, source of income discrimination. A landlord can't just say no Section 8. We don't accept Section 8. That's discrimination based on the source of income. That marital status, a landlord can't say we only rent to people who are married, or we only rent to single people. Familial status, they can't deny renting to you because you have small children. And similarly with some of these other protected classes, landlords can't discriminate against you. And then some of the most common issues of discrimination that we see are disability discrimination, and because tenants with disabilities are entitled to make reasonable accommodations or reasonable modifications to the rental unit that are necessary basically to allow them to fully enjoy and use the unit. And a landlord or a housing provider refusing to make those accommodations and practices, services, or rules, or actually the physical space, such as like a railing or something like that, could be liable for discrimination. And one of the most common ones we see with that is landlords just flat out denying a tenant who requests to have an emotional support animal or something like that. They are required to make those types of reasonable accommodations, as long as it's not an undue financial or administrative burden to them. So they're required to at least go through what's called an interactive process to determine whether what your request is reasonable, and also to determine if there's other alternative options that still allow you to, fully enjoy and use your unit. Now, if you feel like you're being discriminated against or your fair housing rights are being violated, these are some options for you. There's the California Department of Fair Housing and Employment, which is actually now called the Civil Rights Department, and you can make a complaint with them online, over the phone, or via email. But it's important to note that in most cases, you need to file that complaint within 1 year of when the harm actually occurred. And usually the harm that's occurring to you has to really be directly connected to whatever that protected status is. So for instance, the refusal to rent to a family because they have young children, like I mentioned, that's discrimination based on familial status. And, whatever the harm is there is directly related to that status, which is having small children. Also, housing and urban development, especially if you're, have a housing choice voucher or you're in public housing or something like that, making a complaint with HUD. They have online, over the phone, or email as well. And with both these agencies, they'll conduct an investigation and then, either take their own action or basically tell you that now you have a right. If you want, you can go sue them. And then the other options, are small claims court, which is capped at $10,000, as I mentioned before. And you're not allowed to have an attorney. They're not allowed to have an attorney. And then for, issues with damages over $10,000, a civil suit. But those are really hard to do without private counsel. So we definitely recommend reaching out to private counsel. There are private tenant attorneys out there who take cases on contingency sometimes, which basically means that they'll do the work for free. And then if they win, they'll just take a percentage of whatever those winnings are. So that's the end of the presentation. These are just some additional tenant right resources, because we at HERA, we saw a space in the landlord tenant sphere where people weren't getting services for all these issues that I covered before eviction actually happens, because there are a lot of agencies like these listed here that do eviction defense. So if you've received what's called an unlawful detainer or summons, which is the actual lawsuit that's trying to evict you, and that's usually after there's the 3-day notice or the termination notice, we don't provide those eviction defense services, but these agencies listed here, most of them do, especially Eviction Defense Center, Central Legal, Bay Area Legal Aid, and some of these other agencies just provide other good resources for tenants. And then this is just a quick rundown of what we do at HERA. As I mentioned, we cover a bunch of different things. Debt collection. I know we're having a next month, there's going to be that student loan debt training, which is really important because in October, the student loan payments are going to restart. The pause is going to be over. So it's really important right now to kind of get ahead of that, figure out what payment plan makes sense, figure out if there's a way that you can discharge some of your loans. We deal with all sorts of other debt issues, medical debt. For people who are actually being sued on debt, we help them in our pro se, which is they're representing themselves, but we can really help them respond and go through the process of responding to a lawsuit from a debt collector, because if they don't, and there's a quick timeline you have to answer within 30 days, people end up getting a default judgment. Also, something we do is credit reporting. We help people access their credit report, fix errors on their credit report, kind of strategize how to increase their credit scores. And then we definitely help with homeowners. Usually it's just focusing on foreclosure prevention and mortgage servicing. And then the one area that isn't completely free is estate planning. So like wills, trusts, power of attorney, stuff like that we offer, but it's on a sliding scale. So really, it's not free, but it's based on your income. So it's very reasonable. So, and this is our contact information here. If you need help with any of these issues, or you have, specific issues that you just want to talk about, you can give us a call there and you'll get an appointment with one of our attorneys. And now I'll take, I have plenty of time now to take questions. Really, this time's for general questions. If you have more specific questions that have to do with like your personal issues with your landlord, it's probably best if you reach out to us, just because it's best to keep those conversations confidential. But I'm happy to take any questions right now, and I'll go through the chat first and start answering those. But thank you. And yes, I will share these slides, and I believe this is going to be posted online as well. So for a statute of limitations for small claims, usually the statute of limitations in California for a written contract, which would be a lease, is 4 years. If it's oral, so if there's no written contract, it's 2 years. So, and that's in general, not just for a rental agreement, for a lease, that's for other debts as well, loans, stuff like that. The statute of limitations is 4 years. Sale of property included in no fault just cause? So not necessarily. If they're just selling the property, it doesn't necessarily fall under a just cause. But if, say, they're taking it off the rental market, or if the new owner is moving in or something like that, it could fall under just cause. So I would definitely check in with us specifically, especially if you receive some kind of notice about that, to see. How is Berkeley able to still have their moratorium? I think I'm not sure. I don't think it has to do with money. I think it's just they decided that it was necessary to extend it and to protect the tenants a little longer. I'm not really sure if there was financial considerations with that. I don't think so. And yes, the city council definitely voted on it. So if you want to see their reasoning behind it, I would definitely go there, and you can look at all the debates that they had over it. And I know in Oakland it was a pretty robust debates going on at the city council when it was potentially going to get renewed. So our landlords permitted to have security cameras on the exterior of the property. So yes, landlords are able to have security cameras on the exterior of the property or in common areas. And, there could be an argument that that's to protect the safety of the tenants, but a landlord can't have a security camera, say, even though it's outside of the property, if it faces and it can see inside your unit, that I would say would be impermissible. And it really, a lot of it is based on what like your reasonable expectation of privacy is. Whereas, having it outside facing on the street or a walkway or something like that, you wouldn't have a reasonable expectation of privacy there. Whereas if it's faced in internally, and it can actually see into your unit, into your actual private unit, then that's not allowed. But yeah, if it's, hallways, say if it's an apartment building or something like that, or an entrance, that is allowed. But again, like I said, only if it doesn't invade into your privacy. And we've seen issues before where maybe there's a camera in the hallway, but it's faced at your door and it can see into your place when you open the door. That wouldn't be allowed. But just a general camera in the hallway for security reasons or whatever, as long as it doesn't, invade your reasonable expectation of privacy, then it usually is okay. Who should the landlord contact if the property has been deemed inhabitable and the landlord is not responding to any communication? So I think I went over that, but definitely code enforcement, the health department, and then, if they're still not responding, like I said, I would think about doing repair and deduct, withholding rent, small claims court, but definitely talk to us about that first, because that really depends on the severity of the issue and kind of how much notice you've given to the tenant. or to the landlord. So when the landlord is fixing the unit and the tenant with young children is made to live in a hotel, is this tenant responsible to pay the rent for the months that they were asked to stay in the hotel? So no, like as I mentioned, if the habitability issues are so severe that you're forced to, that you have to relocate or something like that, and it's not your fault that the issues exist, then yes, the landlord could potentially be liable to pay for those, for the hotel, while they're fixing it. So can you offer consultation to clients who are navigating issues with their housing voucher and have challenges with local housing authority? Yes, we definitely can. And that's a very common issue we see actually. Housing authorities definitely are overburdened and short-staffed, and it takes them so long to respond sometimes. So definitely that's something we help with a lot, just kind of communicating with housing authorities, filing appeals if your voucher, for instance, has been terminated, all sorts of issues with housing authorities. That's definitely right in our wheelhouse. So we definitely encourage you to reach out to us if you're having any issues with your voucher or with the housing authority. If the landlord pays for the hotel, does the tenant still need to pay for the uninhabitable unit? So that really depends on the severity of the issue. So in certain circumstances they wouldn't have to, but in certain they would. So I would really reach out to us to see, because it really depends on what the habitability issue is. And how it came about, what notice you gave to your landlord, how long it took them to fix it. There's a lot of factors that determine, the extent to which a landlord has to actually pay. So can we elaborate on the assistance we give to veterans? So we don't deal with like a lot of VA issues necessarily. But we do provide, say, if there's a veterans group who wants a training like this, or stuff like that, we definitely are willing to focus on veterans and veterans groups with all of these different issues that we work on. So we don't necessarily do VA stuff, but we're super happy to, if there's like I said, a veteran organization who wants a debt or financial wellness workshop or wants a credit workshop or one of these workshops, we're super happy to do that. Okay, now I guess that's all the questions in the chat. I'll open it up to just general questions. Oh, here, so we have another one in the chat. Yeah, bigger picture question. What do you think will be the impact of the moratoriums ending? Yeah, I think unfortunately it's going to be a lot more housing insecurity, because people are still, the economy hasn't recovered from the pandemic. People are still struggling. So that's why, we were pushing to extend these moratoriums even longer. But that's why it's really important on the local level to advocate for more eviction protections, more just cause protections, higher relocation payments, all of that on the local level. But, unfortunately, the impact of these moratoriums ending is that the landlords have been itching to evict people, and they'll probably start doing that. So that's why it's super important to advocate, and if they are receiving notices or something like that, to have them contact someone like us so we can get ahead of it as fast as we can. Is there any protection for someone in transitional housing? So as I mentioned, some of these just cause protections don't necessarily apply to that, but there is a process specifically for transitional housing in California. And I, off the top of my head, I can't go into too much detail about it, but there is usually a notice, some kind of warning that has to be given, and usually kind of there is a process that has to be done to evict a tenant in transitional housing. but it doesn't fall under the general landlord tenant laws. It's usually specific to that place, or maybe what funding that transitional housing is getting, and usually it's connected to that. Okay. Do we have any other questions?
I have a question.
Yeah.
So in a situation where a tenant is being asked to pay rent, accumulated rent for the time that they were placed in a hotel, what steps should the tenant do or take to resolve it if the landlord is asking for the rent payment?
So usually it would be, a letter to the landlord disputing it. But like I said, with that issue, it really depends on how the communications went with the landlord originally, what the actual issue is. So that, I think, is a more specific issue that I recommend reaching out to us about, because that's something that we'd really have to look at the notice, look at the amounts and all of that to really determine who's liable, and also, what the landlord is saying in that demand that they sent. So definitely I would refer that to us, and we can get a consultation with one of our attorneys about it.
Okay, thank you very much.
Oh, that's great. Yeah, I've referred older adults for assistance with estate planning, and HERA has been helpful. Yeah, our estate planning team is really great, and like I said, it's sliding scale, so that's really helpful for low income people to get a will or a trust or something done and not have to pay hundreds of dollars an hour or thousands of dollars to an attorney.
Also, I have another question. If the landlord did not return the deposit, how long does the tenants how much time does the tenant has to claim it or to do something about it?
So the landlord has to return it within 21 days, or it could be considered an unlawful retention. And then, similarly to the statute of limitations for a landlord being able to sue you on something, the statute of limitations would be 4 years for that, as long as you have a written lease with the landlord. So you would have 4 years to sue them. But like I said, they have 21 days to return it to you. Or to, if they're keeping all of it, to send you that written statement and itemized receipts and, itemized list, all the receipts and everything showing what deductions they made.
So in a situation they didn't do that, only 4 years?
Yeah, so 4 years. Yeah, so if it's past 4 years, I would, there might be different circumstances depending on, if they made a partial payment or, other factors that might extend that or might restart the 4 years. But generally for contracts, the statute of limitations is 4 years, and that's considered a contract because it's in a lease and the security deposit was part of the lease.
And then also, does the landlord, when during time, during moving out, does the landlord has to force the tenant to sign certain agreements, not to sue them or anything?
No, you're not required to sign any agreements like that when you move out.
Okay, so if the tenant reached out to you guys, you can work with them?
Yeah, absolutely. With something like that, you should definitely have them reach out to us.
Okay, thank you.
Yeah, welcome. What is low income now in Alameda County? I'm not sure about that. But we do at HERA, we do low and moderate income people. So a lot of the other nonprofits that I listed maybe have lower thresholds. I'm not exactly sure what ours is right now because it's changing, but usually ours is a little higher because we cover low and moderate income.
So Aren, I was thinking, I think it used to be 60,000 for the moderate because how expensive it is to live in Alameda County and the Bay Area, from what I remember. So I was just checking. I'll send an email to info inquiry. But yeah, I know the best way is to refer.
Yeah.
And
yeah.
that was thinking about the estate will part in terms of referrals.
Yeah, I would reach out to, because that does change sometimes, but yeah, it's usually higher for us because we just saw that need. I mean, people making 60,000 can't afford to go get a lawyer to do some of these things, so we saw that as really important. So, and any other questions? Okay, so like I said, feel free to reach out to us at this phone number below, or you can go on our website, and there is an email address that you can reach out to for questions, and you'll get a consultation set up with one of our attorneys. Yeah.
So I don't know if I missed it. I'm sorry if I did. Can you talk a little bit more about the financial products recommendation for small loans and credit building products? And if we had clients we worked with that might be beneficial for, what's the best way to connect them with that? Is that just to do the referrals? And maybe if you could talk a little bit more about what resources you have on that end, because a lot of folks need that credit building piece.
Yeah, definitely. Yeah. So that's not something I work on as much, but as far as financial product recommendations, I would definitely just refer them to us, and they'll get a consultation set up. But usually, we start with helping the client access their credit report for free, going through it line by line, and really first like figuring out what errors there are that can get corrected. And then things like secure credit cards, lending circles, low interest loans from like banks or credit unions. And we really have we advise clients on how to read like the Truth in Lending Act box, how to evaluate, what's good debt versus bad debt, and really look at the numbers of a loan or of credit that they're being offered to see if it makes sense for them. So that's definitely, we can help recommend like different, secured credit cards, lending circles, stuff like that, like I mentioned. And that's also a workshop we offer as well, kind of like a financial wellness workshop, which goes through all those issues of credit and debt and how to deal with debt collectors, stuff like that.
Just checking to see if anyone else has any questions. If you have any questions, feel free to unmute yourself or raise your hand. Okay. Well, I just want to say thank you everyone for sharing your questions, and for Aren for being here and being present with us today and sharing all this informative presentation. Oh, I have one person. Yes.
Hi, I'm so sorry. I do have a question. So
Sure.
I have some clients, and when they have a Section 8 voucher, but when they're looking for housing, people like on the website, like on Zillow or wherever they're looking, it states not accepting Section 8. Is that legally okay? And the clients have to call like every location they find, every housing location, and they ask, do you accept Section 8? Is that a normal process?
They shouldn't be doing that. Like I said, that denying people just because they have Section 8 is can be considered discrimination on the source of income. So I would definitely refer them to us about that and see why. I mean, they might have some other reason that I can't think of for doing it, which is why I would want you to refer them to us or someone else to actually look at it. But generally, no, they can't just say no Section 8. And I would definitely be interested in seeing which landlords are doing that so we can look deeper into it.
Thank you.
You're welcome.
I think we have another hand up. You're welcome to unmute yourself.
Hello.
Hi.
Yes. Can you send us the slides of this presentation? It's very good.
Yeah, sure. So I'll share it with Leah and Catherine, and then if they want to share it with you, that's totally fine.
I
Thank you.
just put the link to the materials folder in the chat.
Oh, good.
Yeah, so, but if you have trouble, for some reason, some people have trouble with, it's in a Google folder and some people have troubles with that. Just let me know and I can email it to you directly.
Thank you.
And anyone else? I just want to make sure that I want to give space to those who still have questions. Okay, sounds good. Well, thank you so much again, Aren, for being with us today and sharing all this great information, and for all of you folks joining us today. Again, the links are in the chat, the materials, the HERA YouTube, and also our First 5 Alameda County YouTube channel link is also in our chat as well. And we look forward to seeing you guys in future trainings. Again, you will receive a short survey, and we do appreciate your time and feedback. Thank you, folks, and have a nice day.
Thanks so much, everyone. Bye-bye.